virtually virtually gavel in this Commission on Ethics hearing. As you can tell, we are doing this via Zoom for this public session. Ms. Westbury, could you please call the roll?
Yes, Commissioner Bain, Commissioner Bush, Commissioner Fuste.
Bush is here.
Okay, Commissioner Fuste.
Fuste's
All right, Commissioner Hellman,
here.
Commissioner Lyle,
Present.
Commissioner Lucas, Commissioner Phillipson,
Here.
Commissioner Rogers,
Here.
Commissioner Stewart.
Here.
We have a quorum present.
Thank you. Commissioners, please mute your mic unless you are speaking and keep your video on for the duration of the meeting. Also, please silence your cell phones as notifications can be disruptive to the live feed. If you're working out of your offices, also mute your office phone as well. If you're a respondent or an attorney with a matter on the agenda today, please mute your microphone and camera until your case is called. Thank you. Before we get started, even though we're virtually, let's do the Pledge of Allegiance. If you can stand, we'll do our best. Pledge allegiance to the flag of the United States of America and to the republic which it stands, one nation, under God, indivisible, liberty and justice for all. Wouldn't be a commission hearing without it. So, first on the agenda is we'll consider the joint stipulation and complaint number 21-017, 21-031, in re John Stevens. The first item for our consideration today relates to a complaint where probable cause was found in a previous meeting of the commission. And we now have before us a proposed joint stipulation between the commission advocate and the respondent. After considering all the materials and the presentations of the parties, the commission may vote to approve or to reject the stipulation. If a stipulation is rejected, the parties cannot renegotiate and present a new stipulation at this meeting. The complaint would go to the Division of Administrative Hearings for an evidentiary hearing, or the parties could negotiate a new settlement for consideration at another commission meeting. Will the respondent or their counsel please identify themselves for the record?
Good morning. This is Attorney Rob Robinson. I represent the respondent, John Stevens.
Is Mr. Stevens planning to attend, Ms. Robinson?
He is not, sir. It's just myself.
Thank you. Complainants have the right to respond in writing to proposed stipulations. The complainant in this matter did not file a written response. Are there any members of the commission who need to make a disclosure regarding this case? If so, please state that for the record at this time. Seeing no disclosures, Mr. Burns, you're recognized to present the stipulation.
Thank you, sir. Good morning. This agreement would resolve two allegations against respondent who serves as a commissioner for the Cedar Hammock Fire District. Per the agreement, the respondent will admit to one allegation of misusing his position and agrees to pay a fine of $1,000. And the other allegation of misusing his position would be dismissed as the evidence does not warrant moving forward. I ask that the commission approve the agreement in lieu of further proceedings. That's all I have unless there are questions.
Do any of the members have questions for Mr. Burns? Seeing none.
I'd move approval.
Ms. Robinson, did you have anything further you would?
No, sir, I do not.
Okay. Is there any questions for the respondent by any of the members? Ms. Robinson? Okay. Let's move. Is there anyone that would like to have any discussion or debate about this stipulation? Seeing none, I'll entertain a motion on adoption of the stipulation.
So moved.
Second.
Commissioner Lyle moved, Commissioner Rogers second. I'm going to call for a roll call vote. Instead of us doing by voice vote, Ms. Westbury, can you do a roll call of the members so we can get a good number?
Yes, Commissioner Bush,
Yes.
Commissioner Fuste,
Think we may have lost Commissioner Fuste to technical,
right.
some tech issues.
I'll
But
come
we
back
still
to
have a
him.
quorum.
Commissioner Hellman,
Yes.
Commissioner Lyle,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart.
yes,
All right, motion passes.
Thank you. We will move on. Ms. Robinson, thank you for your time. And the stipulation has been adopted. Moving to the next item on our agenda is a consideration of dismissal of certain allegations in a complaint. This is complaint number 17-107, N. Ray Susan Haney. The commission previously found probable cause in the complaint filed against Ms. Haney. The complaint was referred to the Division of Administrative Hearings for a public hearing to determine if Ms. Haney had a conflicting contractual relationship. Staff has prepared a draft for our consideration to dismiss certain allegations in the complaint. Are there any members who need to make a disclosure at this time?
Yes, Mr. Chair. I served on the board with Ms. Haney as a council member for the city of Boca Raton. I've spoken to her general counsel. There's no legal conflict. I intend to proceed here.
Thank you, Commissioner Rogers. Will the respondent or her counsel please identify themselves for the record?
Mark Heron on behalf of Susan Haney.
And Ms. Haney, I see, is in attendance. Ms. Haney, can you identify yourself for the record?
yes, Mr. Chairman, Susan Haney for the record.
I'll recognize Amelia Naomi to explain the draft order.
Thank you, Mr. Chair. So this draft order currently before you recommends that you dismiss certain allegations contained within complaint number 17-107 for lack of jurisdiction. Now, before I give you the background on this complaint, let me give you some context regarding the recent changes in our statutes and why we are now recommending dismissal of some of the allegations in the complaint. So as you know, during the 2024 legislative session, the legislature added language to section 112.324, indicating the commission could only investigate allegations in a complaint that are based on personal knowledge or information other than hearsay. That law restricts the commission's jurisdiction when it comes to complaints to only those kinds of allegations. Now, based on our research, we've concluded that this new jurisdictional standard, requiring an allegation to be based on personal knowledge or information other than hearsay, does apply retroactively to all active cases before the Ethics Commission, even those that were ordered to be investigated before the change was made and took effect. Now, there are two reasons for this. First, the legislature could have tied this change to a particular date, but chose not to, which implies it was to affect all active cases at the commission, even those that were already being investigated. Second, the appellate courts have found that changes affecting an agency's investigative jurisdiction should be retroactively applied unless the legislature specifically states that they are only to take effect moving forward. An example of this can be found in the case of Jennings versus Florida Election Commission, and that's Florida's second DCA 2006 case. So now turning to the facts of this case, in this case, based on the allegations in the complaint, a preliminary investigation was ordered to determine whether the respondent had violated section 112.3145 Florida statutes, which is disclosure of financial interests, section 112.3143 sub 3 Florida statutes, which is our voting conflict statute, section 112.313 subsection 7A Florida statutes, which is conflicting employment or contractual relationships, and section 112.313 subsection 6 Florida statutes, which is our misuse of public position statute. Now, ultimately, the commission found probable cause on all of these allegations, and this matter is now pending a public hearing at DOA or a stipulation between the respondent and our advocates. Now, in light of this new jurisdictional standard, commission staff reviewed the allegations in this case to see if they would still be legally sufficient to investigate under the new standard. Upon reviewing the complaint allegations, it appears that only some of them would have been found legally sufficient for investigation had this complaint been filed today. These allegations are that respondent violated section 112.3145 by filing an inaccurate 2012, 2013, 2014, 2015, and 2016 CE Form 1. So these allegations appear to meet our current investigatory standard as they appear to be based on respondents' own CE Form 1 filings, and these would likely be admissible under both the admissions and the public records and reports hearsay exceptions. These allegations are also based on records from the Florida Division of Corporations, and these would likely be admissible under both the public records and reports and records of regularly conducted business activity hearsay exceptions. So the other allegations, which I'll outline in a moment, appear to be based solely on information that the complainant became aware of through news articles. As such, the draft order before you recommends their dismissal, as these news articles are inadmissible hearsay, and it does not appear that the complainant in this matter otherwise had personal knowledge of the alleged conduct. So the allegations we are recommending for dismissal are as follows. First, that the respondent violated Section 112.313 subsection 6 by concealing a business relationship and voting on matters which resulted in a benefit to her, her husband, their businesses and or business associates and their companies. That respondent violated Section 112.3143 Florida statutes by voting on matters which she knew would inure to the special private gain or loss of herself, her spouse, and or a business associate or principal. And that respondent violated Section 112.313 subsection 7A Florida statutes by having a private interest and business relationship with James and Marta Batmasian and or their companies while they or their representatives appeared before the Boca Raton City Council. So therefore, should you choose to vote to adopt the draft order in front of you, the only allegations that will remain will be the allegations concerning respondents' Form 1 filings. The rest of the allegations would not be the subject of any public hearing or stipulation in this matter. Now, I would like to point out to those of you who are new to the commission that if you choose to adopt the draft order in front of you, this will not be the first time the commission has dismissed certain allegations in an active case that we did have jurisdiction to investigate when the complaint was first filed. But if it had been filed today, we would have had to find those same allegations legally insufficient because they don't meet the personal knowledge or information other than hearsay standard. So thank you for your time. I'm submitting the draft order to you now, and I'm happy to answer any of your questions.
Do any of the members have questions for Ms. Naomi?
I do. This is Commissioner Lyle.
You recognize?
Thank you. And at the outset, I don't think I'm going to disagree with the conclusion, but I'm very sensitive to characterizing application of new law as retroactive. And I just want to be clear that we're not talking about retroactive for closed cases, for instance, but instead what I think you're really saying, and if you could confirm this, I would appreciate it, is that the new law applies to anything on which a final determination has not yet been made.
Through the chair, yes, that's how we've been applying it. It's just to cases that we still have in front of us.
And so with all due respect, I'm not sure I would consider that retroactive necessarily. And that's just the reason for my comment and wanted to clarify. Thank you.
Thank you, Commissioner Lau. Any other members wish to comment?
Mr. Chair, question for Ms. Naomi. I don't think it's relevant because I think it applies to the charges that we're recommending dismissal. But to my recollection, I think the city attorney for the Boca Raton on behalf of the respondent had asked an opinion on something similar to this matter. I know it was quite some time ago. Can you did the city officially seek an opinion on anything related to this or to that voting and relationship around this time?
Through the chair, I am not aware of that. They could have, but I'm not aware if they did or not.
Mr. General Counsel, do you have any information?
I do. In the complaint amendment, it references that the respondent or someone, the city council on behalf, the city attorney on behalf of the respondent asked for an opinion from the local ethics commission, not from us.
Thank you. Any other members wish to ask any questions or comment any questions at this time of Ms. Naomi? Seeing none, Mr. Herron, would you like to make a statement?
Just briefly, Mr. Chairman, the staff did an excellent job of summarizing the case law and the effect of the 24 amendments. I was the counsel on the Jennings case, and I've been the counsel on another case that's been litigated in Palm Beach County about the effect of these amendments, and I won't use retroactive because Commissioner Lyles is concerned about that word. But again, the staff's analysis is correct, and I would urge the commission to adopt the order amending the charges against Ms. Haney.
Thank you. Do any of the members have any questions for Mr. Herron? Seeing none, we'll move to discussion and debate. Do any of the members wish to discuss the matter before us? Okay. Seeing no discussion, we will move for the adoption of the draft order. Ms. Westbury, can you please call the roll?
Commissioner Bush?
Yes.
Is Commissioner Fuste back? No. Commissioner Hellman?
Yes.
Commissioner Lyle?
Yes.
Commissioner Phillipson?
Yes.
Commissioner Rogers?
Yes.
Commissioner Stewart?
Yes.
Motion passes.
The proposed order has been adopted and will be signed in due course. Moving to the next item on the agenda. Thank you, Mr. Herron, for your time.
Thank you.
Client has
Appreciate
already-
it. Thank you.
Thank you, Ms. Haney, as well.
Thank you, Mr. Chair.
The consideration of advocate's motion to dismiss complaint. This matter is the consideration of the advocate's motion to dismiss complaint number 23-002 N. Ray Lori Cunningham. If the commission grants the advocate's motion, the matter would be dismissed. Alternatively, if the commission were to deny the motion, the case would proceed to the Division of Administrative Hearings for an evidentiary hearing, or the parties could reach a settlement agreement. Are there any members who need to make a disclosure? Seeing none, just verified the respondent and her counsel are not in attendance. Ms. Stillman? I see her mouthing. That is correct. Okay. All right.
Sorry, that is correct.
Ms. Hadley, you're recognized to present your motion.
Thank you. At the relevant time, respondent served as a member of the Polk County School Board and owned Applied Images Incorporated, which is a business that sold school uniforms. Respondent's corporation was doing business with the Buck Middle Academy, and the Lake Wales High School, which are charter schools under Lake Wales Charter Schools in the school district. And she was doing business by selling mandatory school uniforms to the schools and or parents. I initially recommended probable cause based on the preliminary investigation, which was accepted by this commission. In preparation for the trial, the parties engaged in an alternative dispute resolution program, which is basically mediation, exchanged information, interviewed witnesses, including the school board's attorney and the CFO of the charter schools, and reviewed the current statutes as they relate to charter schools. Previously, in Commission Opinion 97-7, the Commission opined that charter schools were at minimum subject to the regulation of the school board. However, Florida statutes have evolved since that opinion was issued. For instance, under Section 1002.33, subparagraph 5B1D, Florida statutes, the sponsor, which is the school board in this situation, it says that not all of its policies apply to the charter school unless mutually agreed upon by each party. For a violation under Section 112.3137 Florida statutes, it must be established that respondent must have been employed by or have had a contractual relationship with a business entity that is subject to the regulation of her agency, and or that relationship created a continuing or frequently recurring conflict between her private interest and the performance of her public duties. While Polk County School District is the sponsor of the charter schools, the law has limited the school district supervision of charter schools to essentially a periphery overview if it meets the minimum guidelines. In addition, the charter schools have their own board of trustees. Those parents of the charter school students would contact that board of trustees with concerns regarding the students. Respondent was not in a position to favor her public interest over her private interest over her public responsibilities to the school district. I ask for this case to be dismissed.
Thank you. Any questions from the members for Ms. Hadley? Seeing none, we will move, the respondent not being present, we'll move to discussion and debate. Is there any member that would like to discuss this matter? Seeing none, we'll move for the adoption of the order dismissing the complaint. Ms. Westbury, will you call the roll?
Commissioner Bush,
Yes.
Commissioner Hellman,
Yes.
Commissioner Lyle,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart.
Yes.
Motion passes.
Thank you. Thank you, Ms. Hadley. The motion has been adopted and an order will be entered in due course. Moving next to the next item on the agenda, the consideration of advisory opinions. This is file number 2823. Any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of disclosure laws or standards of conduct to himself or herself, or anyone who has the power to hire or terminate another public employee, may seek an advisory opinion from the commission about himself, herself, or that employee. Advisory opinions are based solely on the facts provided by the requester and are legally binding on the conduct at issue. Are there any members of the commission who need to make a disclosure regarding this matter? If so, please state for the record at this time.
As Commissioner Lyle, I would like to disclose that I know Dave Ehrenberg personally. I am not involved with his business affiliations. Most importantly, for the record, I'm not a client, but I do know him and would like to make that disclosure. I've spoken to General Counsel about this, and I do not need to recuse myself. Thank you.
Thank you, Commissioner Lyle.
Yep, Mr. Chair. Likewise, I know Mr. Dave Ehrenberg from my time in Palm Beach County. I don't think there's any issue that he ever represented from our board when I was on the council for City of Boca Raton, and certainly no business dealings with him. I don't plan to recuse myself on this issue.
Thank you, Commissioner Rogers.
I'd like to also say that, of course, I know Mr. Ehrenberg. I don't know who in Florida who doesn't, but I have no reason to recluse myself today.
Thank you, Commissioner Stewart. Will the requester please identify himself for the record?
Hi, this is Dave Ehrenberg, and thank you, Commissioner Stewart, that everyone in Florida knows me. The voters in 2010, when I ran for Attorney General, would say otherwise. But I'm Dave Ehrenberg, Dave Ehrenberg Law.
Thank you, Mr. Ehrenberg. We'll move to the staff presenting the draft opinion. Mr. Schaefer.
Yes, Chair.
Present the opinion.
Thank you, Chair. This opinion request, as you've heard, is being brought by Dave Ehrenberg. He's the former state attorney for the 15th Judicial Circuit here in Florida. He left his position in January of this year, and since then he's opened up a private law firm that focuses, at least in part, on criminal litigation. His question for the Ethics Commission is pretty straightforward. Is he prohibited by any of the state ethics laws from representing criminal defendants in cases that his former office is prosecuting? And he specifies in his inquiry that he and his firm are going to limit their criminal representation to matters where charges were not filed until after he left office. So this won't be a situation where he'll be defending clients in matters that he initiated in terms of charging while he was still serving as a state attorney. As you know, there's several different post-employment laws that the Commission has jurisdiction over. The ones that are most relevant to this particular inquiry concern returning to represent a private client or a new employer in a matter involving your former agency during a certain window of time after you've left your public position. But importantly, those laws are very limited in their application. They don't apply to all former public officers and employees, but only to those particular positions specifically listed in the language of the statutes themselves and of the laws themselves. So unlike some other recent advisory opinions you've had that have kind of hinged more on questions of policy or on very unique facts, the analysis here is more mechanical. It's more cut and dried. Looking at each of these post-employment laws, do any of them, by their language, apply to the position of a state attorney? Now, several of these laws, by their very language, do not. For instance, there's a prohibition in the state constitution that restricts certain types of public officers from returning to represent clients before their former agencies for 6 years after they leave their position. It's found in Article 2, Section 8F of the state constitution. But by its language, it's limited just to certain categories of former public officers. It's limited to statewide elected officers, members of the state legislature, the heads of executive branch departments, and certain high-ranking local officers. And a state attorney just doesn't seem to fit within any of those categories. They are elected, but they don't have statewide authorities. They're not a statewide elected officer. They're not members of the legislature. They're not the heads of executive branch departments. There's actually 20 different state attorneys, one for each of the different 20 judicial circuits in Florida. And they're not local officers. So again, they just don't seem to fit with any of the categories mentioned in the language of this constitutional prohibition. Also, even setting that aside, there is an exception to this constitutional post office holding prohibition if what you want to do as a former officer is to represent clients in legal proceedings in courts of law. And that's exactly what Mr. Ehrenberg wants to do here. He wants to represent criminal defendants in court proceedings. So that kind of takes care of the constitutional post office holding prohibition. But what about the ethics statutes? Well, the main post-employment statute is found in Section 112.313, subsection 9A. And that particular subsection, 9A, has several different separate subsections, each of them setting out different prohibitions. One of them is very similar to the constitutional prohibition I just went over. It's a representation prohibition, but again, it only applies to certain kinds of public officers mentioned in the language of the statute. It's limited to former legislators, appointed state officers, and again, statewide elected officers. And a state attorney just doesn't fit within those categories. They're not a legislator, they're not appointed, they're elected, but they don't have statewide authority, so they're not a statewide elected officer. Now, that being said, there is a separate part of Section 112.313, subsection 9A, that we need to go into more detail on. It requires the closest analysis because it probably captures the most amount of people within its reach. It casts the widest net. It's found in Section 112.313, subsection 9A4. It applies to certain former executive and legislative branch employees, and it places a 2-year prohibition on them returning to represent a client for compensation before the agency where they were employed. And unlike the constitutional prohibition I just talked about, there's no exception in the statute for representing clients in court proceedings, in proceedings before a judge. But that being said, it's the position of a state attorney covered by Section 112.313, subsection 9A4. Like I said, it only applies to former executive and legislative branch employees serving in certain kinds of positions enumerated in the statute. So I guess the threshold question here is the position of a state attorney an executive or legislative branch position? Which is kind of a more controversial question that the courts haven't really clearly answered. You know, a state attorney is created in Article 5 of the state constitution, that position, which is the part of the Constitution dealing with the judiciary, but they exercise the executive power to prosecute in criminal matters. So the courts haven't really clearly come down on what branch of government they're in. And a footnote in the draft does touch on that. But thankfully, the Ethics Commission doesn't have to answer that controversial question to analyze the applicability of this statute, because regardless of what branch of government the state attorney is in, this position just doesn't fit any of the other qualifying criteria laid out in the statute. Now, by far the most broadest criteria is that this particular part of the statute applies to former executive and legislative branch employees who are serving in senior management service or selected exempt service positions, SMS or SES positions. Those are HR classifications really set by the Department of Management Services by DMS. But both SMS and SES classifications require that DMS sets the position's salary. And as you can read in the draft, the Florida statutes are very clear that the salary for a state attorney is not set by DMS, but by the legislature through the General Appropriations Act. So because of that, because DMS doesn't set the position salary, they don't qualify as SMS or SES, so this post-employment law can't be applied to them on that ground. Now, the draft describes that, but after we issued the draft to you all, Steve and I wanted to make crystal clear that a state attorney was not within the SMS or SES systems. We actually called DMS and had a conversation with them about whether or not a state attorney is on an SMS or SES list. And they clarified to us that they did not believe a state attorney was an SMS or SES classified position. But they said, look, these are technically HR classifications, and it's the Justice Administrative Commission, the JAC, that provides HR support to state attorney offices. So they suggested we contact the JAC as well, just to make certain that they as well didn't have any thoughts on the matter. So we did call the JAC. We had some conversations with their general counsel, and she agreed with us that because the state attorney's salary is not set by DMS, but by the legislature, they should not then be considered an SMS or SES employee. So this is probably the broadest criteria in the statute, but we've talked with all the state agencies that we most know on this, and everyone is in agreement that a state attorney is not an SMS or SES position, and therefore that this statute can't be applied to them on that ground. Now, the draft does discuss some other factors that could kind of rope a former employee into being subject to Section 112.313 subsection 9A4. But as the draft explains, none of those other criteria really appear applicable here either. And if you'd like me to go into more detail on them, I can. But long story short, we've looked at the constitutional and the statutory post-employment laws. It doesn't seem that any of them apply to a state attorney because that position falls outside the categories that these laws apply to. So there doesn't seem to be anything restricting the former state attorney here from representing clients in criminal matters, even if they're being prosecuted by his former office. I do want to note a couple of things as I close. First, this is not really the first time the Ethics Commission has tackled this issue. Back in 2010, a former assistant state attorney asked the same question. The commission engaged in the same analysis that we're doing today and came to the same conclusion that a former assistant state attorney didn't fall within any of the categories mentioned in these laws. There was nothing prohibiting her then from representing clients in matters involving her former office. And that is discussed in the draft, that opinion. I also want to note that while Mr. Ehrenberg here is not prohibited from representing clients in matters being prosecuted by his former office, he does need to be aware of Section 112.313 subsection 8. This is covered by a footnote in the draft. That's actually the last footnote in the draft. That particular statute would prohibit any former public officer, employee, state or local, from using information they learned in their public position that has not yet been made publicly available to benefit themselves or their clients. It's basically a prohibition on using confidential information that you learned while you're in your position. I don't believe that would prohibit him from taking on these types of cases, but he should just be careful not to use any confidential information that he learned while he was state attorney, again, unless it's been made publicly available. And Steve and I have discussed this. We'd like to add one extra sentence to that footnote that's not in the draft in front of you. It doesn't change at all what we're recommending. It would just caution Mr. Ehrenberg here to be careful if he's accepting cases and matters where maybe charges weren't filed, but he was overseeing the collection of evidence or discussing prosecutorial strategy before he left his position. And those pieces of evidence, that strategy is still not been made publicly available. We just like to add one extra sentence cautioning him about this statute in those contexts. But again, it does not change anything of what we're recommending today. With that being said, I offer this draft now for your review with the addition of that one extra sentence to the footnote. I'm happy to answer your questions. And I know Mr. Ehrenberg is here this morning as well, and he may want to address you too.
Any of the commissioners have any questions for Mr. Schaefer? Ms. Schaefer, thank you for that presentation. Ms. Schaefer, that last sentence, that's ones where situations where there hasn't been a charge raised, but the state attorney's office may have been investigating or evaluating bringing charges, Mr. Ehrenberg would have been privy to that information. That's where
That's
that would
correct.
come in.
And what the sentence would say is it's not maybe per se a violation of section 112.303 subsection 8, but he just should be cautious in those circumstances.
Thank you. Mr. Ehrenberg, would you like to comment on the proposed advisory opinion?
Yes, first I want to thank Mr. Schaefer and your team, Stephen and Zulikowski. You guys did a great job, very thorough. And yeah, I never thought there would be any conflict, but Alexia Cox, who's the new state attorney, she was my deputy chief assistant state attorney, and I supported her. And now she's in an abundance of caution. She just wanted to make sure there was no prohibition. And neither of us thought there were, because there are other state attorneys who go on and make a living as criminal defense lawyers. It's a part of our law practice, not the majority, but it is a part of our practice. And I would like to do what they do. And in fact, there are a lot of assistant state attorneys who leave and then immediately become criminal defense lawyers, and there's never an issue with them. So in an abundance of caution, we just wanted to get something in writing. But of course, as I mentioned in my request, I would never take a case where I was the filing, where my name was on it. And I believe it or not, as soon as I left the office, I got people who I was prosecuting call me up to say, all right, now represent us. And I thought that was just awful and completely unethical. It's an interesting point that Gray makes about if I had information about a case that wasn't filed. I hadn't thought of it, but I will stay away from that as well. This is about new cases, new matters, and I appreciate your consideration.
Thank you, Mr. Ehrenberg, and thank you for attending. Members, is there any discussion we want to have with regards to the advisory opinion before moving to a roll call vote? Commissioner Bush, did you want to comment or have any questions?
No.
Mr. Chair, I have a couple questions, I think, for staff, and then maybe over to Mr. Schaefer. Understanding we're kind of looking at two things, the Florida Constitution and the statutory ethics one. On the Florida Constitution, I think we're fine because of the legal exclusion, but I wanted to ask our general counsel, what would we consider? I don't want to broadly discount, a state attorney from being a local officer. Again, I think we have an exclusion, so we're absolutely fine here. But can you just let me know what you think about that?
Commissioner Rogers, I'm not exactly sure I'm understanding the question. Would you repeat the question? And honestly, I do believe Mr. Schaefer would be very prepared to answer any questions about his draft.
Yeah, absolutely. So Mr. Schaefer, through the chair, on the local, you stated that, different offices and appointed folks and so on who have banned from representing clients in front of their former agencies, but there is a specific exclusion for legal representation. So I think we're covered, and it's a bit of a moot point, but I just wanted to cover what is that definition of local officer in the Florida Constitution? I want to dive in a bit more on that, because I don't know that I would necessarily agree that doesn't fit. With the legal exclusion, I think you're still good to proceed here, but say if it was for lobbying on vendors or something, that would be a little bit different. So,
well, the constitutional prohibition does cover statewide elected officers, members of the legislature, and then it lists a series of local officers. And I would guess, first of all, I guess I would start by saying a state attorney is created in Article 5 of the state constitution. I believe it's pretty much accepted that a state attorney position is a state officer as opposed to a local officer. But even beyond that, if you look at the particular local officers that are designated in Article 2, Section 8F, which is the portion of the Constitution the draft discusses, none of them are a state attorney. It covers county commissioners, county officers pursuant to county charter, school board members, school superintendents, elected municipal officers like city commissioners, elected special district officers that have ad valorem taxing authority. And then it also goes on to talk about those who are heading executive branch departments in the state government. So number one, I don't believe that a state attorney is designed to be a local officer. And number two, that the particular local officers mentioned in the prohibition don't cover state attorneys.
Through the chair, Commissioner Rogers, one other thing about that is not only does the state attorney not fit into the definition of public officer for the constitutional prohibition, but what that prohibition prohibits is quote unquote lobbying for compensation, which is defined in we have implementing legislation for that, section 112.3121. It defines what lobbying for compensation is and then what it isn't. And listed, there are three things that are in the part of what it isn't that are basically the practice of law. And so this is not, the practice of law would not be captured by the prohibition in the Constitution that we now have.
Mr. Chair. Mr. Chair, I just, given that I'm comfortable proceeding on this, I think we're not talking about lobbying and there is a specific carve out for legal. On the statutory side, I wanted to reference that, so I was part of DMS for a while, was in the HR department, but we looked at what types of entities could be covered all the time. If you look at the official organization chart for the state of Florida, state attorneys clearly fall under judicial. So I think that's that's clear as day.
Any other commissioners want to ask questions or comment with regards to the proposed opinion?
If I could, Commissioner, just in response to Commissioner Rogers' observation, I mean, it seems to me like, frankly, it may have been an oversight by the drafters of the constitutional amendment, but nevertheless, since we're all textualists these days, and that's not in the Constitution, I think that even if he was doing something within practicing law, I don't think the state attorney gets caught by that. And I'm certainly in support of the draft opinion, but it does seem like it would have been pretty natural to have included state attorneys in that from that standpoint. Thank you.
Thank you, Commissioner Lyle.
And Mr. Chair, agreed. That's kind of what I was, again, I think because we're talking about law, it's not applicable, but if it seems like what they were intending, and I think probably as it was written, when they say SMS and SES, I think they mean leadership in that case. They didn't write it, but not as long as we're not overarching and overreading into this down the road, it may be something legislature wants to look for on the lobbying side down the road, not what we're looking at here. So I concur 100%.
And Mr. Schaefer, this opinion will be limited to the facts set forth in this opinion and these circumstances as articulated in your draft opinion, correct?
That's correct. And again, if the legislature has the ability to add state attorneys to the statute down the road, but we are trying to, these statutes especially are penal in nature, meaning they could result in penalties. And so the courts have been very clear, the Ethics Commission, because they're penal in nature, has to strictly construe them, meaning we can't go beyond the words that the legislature gave us. And so that's always in mind when we engage in questions about interpreting statutes like this.
Thank you, Mr. Schaefer, and thank you for the extra diligence of reaching out to the general counsels of DMS and other general counsels of the agencies to resolve any lingering questions before presenting it to the commission. That being said, I'll entertain a motion for adoption of the advisory opinion.
So moved, Mr. Chair.
Is there a second?
Second.
Hearing a second. Ms. Westbury, can you please call the roll?
Yes. Commissioner Bush,
Yes.
Commissioner Hellman,
Yes.
Commissioner Lyle,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart.
Yes.
Motion passes.
Thank you, Ms. Westbury.
Mr. Chair, just to be clear, that's the a motion to adopt with the added sentence that Mr. Schaefer wanted to add.
Yes,
That was my
make
motion,
it
yes,
clear
sir.
for the record so that we have that. I'm going to call the roll call vote for adoption of the advisory opinion with that additional note at the end that Mr. Schaefer mentioned. Thank you, Ms. Zukowski, for reminding me of that. Let's call that roll call vote again for this proposed advisory opinion with the addition on that footnote addressing the issue that Mr. Schaefer raised in his presentation. Ms. Westbury, can you recall the vote?
Yes. Commissioner Bush,
Yes.
Commissioner Hellman,
Yes.
Commissioner Lyle,
Still a yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart.
Yes.
Thank you. Motion passes.
Thank you.
Thank you.
I was going to be concerned, Commissioner Lyle, if you changed your vote after that one change.
Exactly. Right.
Mr. Ehrenberg, thank you for attending and providing comment. Best of luck in the new practice.
Thank you. Thank you all very much. Appreciate your time today.
Turning to the last item on our agenda today, it is the consideration of the call center renewal authorization. We will, pursuant to section 286.0114 Florida statutes, members of the public have the opportunity to have input on matters before the commission other than in cases in which we are acting in a quasi-judiciary capacity. The commission did not receive any email comments from the public on the matter before us today. However, if you are a member of the public who would like to speak about the matter of the call center renewal authorization before us and join us from your computer, please raise your hand by clicking the raise hand button on your computer so you can be recognized to speak. Not seeing any hands raised. At this time, I would ask the commission Zoom coordinator to allow the public in attendance by phone the opportunity to unmute themselves by pressing *9. If you are a member of the public joining us by phone and would like to speak regarding the call center renewal authorization, please press *9 and state your name so you can be recognized. Ms. Blaze, did anybody unmute themselves?
No, sir.
Thank you. Based on no public comment, we'll proceed and I'll recognize the commission's executive director to present the renewal information. Ms.
Thank you,
Stillman, you're
Mr. Chair.
recognized.
Thank you, Mr. Chair. Good morning, commissioners. Good to see you. You have in your materials a detailed memo regarding the call center renewal authorization that I seek from you this morning. This is our second year using a call center to assist Form 1 filers with their questions. This was the first year of a contract with ROI Solutions. That contract was awarded at the end of a RFP process that we did with our purchasing office. The expenditure that we were authorized under that contract to make was over $200,000. It was, let's see, $262,416. The actual amount we spent came in almost $89,000 under the amount that was authorized under the contract. And I think that's not only because your staff is interested in being excellent stewards of public tax dollars, but ROI Solutions shared that goal as well. To be good stewards of public funds. The challenge is having competent staffing and staffing levels when we're at our highest call volume, because the process starts very slow, it gets very high very quickly, and then falls off even more quickly. They voluntarily lowered staffing during slower periods. They maintained quality. They handled all aspects of our frontline customer service on the Form 1, from logging questions to questions about completing the form. The project manager and team lead were tremendous assets, continuously monitoring and in constant communication with us. Their oversight of the customer service staff made all the difference. We anticipate call volume will be lower next year, as filers will now have had 2 years of filing experience in the system, and we saw that with Form 6. However, we do still believe we have a need for a call center. Our staff provides the call center representatives and their leadership with at least 40 hours of training before they take their first call. By exercising a renewal that exists within our contract that was executed in 2025, we will have an advantage that we haven't had before, which would be the experienced manager and lead from ROI Solutions to work on this project again. They will already have the training and a full year of experience under their belt. As a result, we will not start at zero in terms of their understanding of the commission, its mission and goals, the disclosure requirement, and all of the details. We anticipate we can be a little more creative with our onboarding and training in leading up to our busy weeks, and possibly realize further savings under the contract. The contract that was in existence in 2025 did allow for a renewal, and that is what I am asking for your position, your approval for us to draft. Under the terms of our existing contract, the renewal would not be drafted at more than the $262,416 in the existing contract. Should you approve this today, we will then have that contract drafted and it will come back before you for your approval of the actual contract. I'm happy to answer any questions you might have.
I have a question.
Commissioner Stewart?
Yes. Is it necessary to budget the same amount when the anticipated volume is going to be much less?
Through the chair, that was the amount noted in the existing contract, that the renewal contract would not exceed that amount. With your authorization today, we will work with ROI Solutions to come up with a renewal scenario that, again, I don't anticipate would exceed what we did this year. We hope to realize further savings in 2026. We have some advantages.
Mr. Lau? Commissioner Lau?
Thank you. Thank you. Yes, if I could chime in on the same spirit as I think Commissioner Stewart was. Not only do we hope you don't come back with something to exceed, but we're hopeful it will be significantly less because of the expected drop-off in calls. And you indicated during a report that these people have now been trained up, and so it should require a lot less effort from that standpoint. So I think Commissioner Stewart and I appreciate looking forward to you coming back with something significantly less than the number that you've mentioned. Thank you.
Through the chair, thank you, Commissioner Lyle. And yes, I would agree with you. One challenge that we do have, we have the advantage of the team lead that we think we can have again, and she is fully trained. The call center representatives, there is no guarantee we will get the same representatives because it's a short term. We hope to. They seem to enjoy doing the work and found it interesting, but I hear you in terms of the amount, and we look forward to bringing a proposed contract back to you that would meet your expectations.
Executive Director Stillman, you also noted this year we had a budget allocated, but we came under by, how much was it? 60,000, 80,000, was it below? How much was it below what we?
It was $88,953.09 below the maximum amount. And that was for 10 call center representatives that we geared up from the beginning. And then they managed the staffing levels to reduce when we had slower call volume. They also, remember, made outgoing calls. So our hope would be that perhaps if we have the same team lead, that we wouldn't have to train all 10 from the beginning. We would start out slower and be able to build better in terms of the maximum we might need to adequately staff at expected service levels.
Commissioner Rogers?
Yep, thank you, Mr. Chair. Executive Director, first, I think I'm a really strong proponent of the call center and the active outreach. Kind of being the former elected local person, I think the nightmare scenario is like you have some poor appointee to a board who's volunteering and then they don't file their form and suddenly they're in stuff with the state and this, sometimes these people barely use email. They may be experienced in other areas, but not technologically experienced. So having this as to make sure they're properly informed is great. Great job saving money, I think, on what was there. I did want to ask, I want to ensure we're not green lighting offshoring in any way from here. Do you know if the current call center, either the leads or the those making the calls, are US based? And if they are, I think there's no problem. I would just look to have that provision in the contract, or at least I would highly recommend we go forward with that. And if there's a huge cost difference, then bring both costs back. But if it's already the case, I think we're good.
Through the chair, that is already the case. And that was something that we specified, that the call center representatives be in the United States. We did not want to offshore that, and that is important to us.
Excellent. Thank you, Mr. Chair. Thank you, Executive Director.
Any other commissioners want to be heard or have questions for the Executive Director? Seeing none, I'll entertain a motion for a vote.
So moved.
Move for the adoption of the authorization for contract call center renewal.
Second.
Commissioner Stewart's moved. Do we have a second?
Second.
Okay. In a second, Ms. Westbury, can you please call the roll?
Commissioner Bush,
Yes.
Commissioner Hellman,
Yes.
Commissioner Lyle,
Yes.
Commissioner Phillipson,
Yes.
Commissioner Rogers,
Yes.
Commissioner Stewart. Motion passes.
Thank you. Thank you, Ms. Stillman. And once,
Thank you.
now that it's been approved, we will have a contract come back to the commission at a later date for our approval. That being the agenda for today, the commission I will entertain a motion to adjourn.
So moved.
Second? Do we have a second?
Second.
Thank you. Here in second, the meeting is adjourned.
Thank you all.
Thanks, everyone.
Have a nice weekend.